The Malaysian court system originated from the Charter of Justice 1807, commonly known as the First Charter of Justice, granting the British East India Company the right to establish a court of justice in Penang. As a Commonwealth country, Malaysia adopted the British judicial system. The hierarchy of the Malaysian civil courts places the Federal Court as the highest court. The Federal Constitution stipulates legislative authority under the Federal Court, High Courts and the subordinate courts. Before the formation of Malaysia in 1963, the Supreme Court in Southeast Asia consisted of three courts: the Supreme Court of Federation of Malaya, the Supreme Court of Singapore, and the Supreme Court of Sarawak, North Borneo and Brunei. In 1963, the remaining British territories were merged into the larger Federation of Malaysia. The 1963 Constitution led to the establishment of the Court of Appeal and the Federal Court of Malaysia, led by the Chief Justice of the Federal Court along with the three High Courts, the High Court of Malaya, the High Court of Singapore and the High Court of Borneo. On August 9, 1965, the High Court of Singapore was removed from the Malaysian court system as Singapore left the Federation of Malaya.
Sharia Court, the comprehensive adoption of the Islamic legal system in the 15th century by the Malay Sultanate of Malacca, was followed by the British advising the establishment of separate courts upon their arrival in Malaya. The Sharia Court, initially part of the national court hierarchy, was later relegated to a lower status by British authorities. In 1948, the court's ordinance separated the Federal Court and the Sharia Court. Post-independence, the Sharia Court fell under state jurisdiction, leading to variations in Sharia law across states. An amendment to the Federal Constitution in 1958 clarified that high civil courts had no jurisdiction over matters within the purview of the Sharia Court, commonly referred to as Qadi Court. It plays a pivotal role in implementing Islamic law in different states.
Next, moving on to the conflict between the Sharia Court and Civil Court. Conflict often arises between Civil Courts and Sharia Courts due to their different jurisdiction. This conflict can be seen firstly in determining whether a matter falls within the jurisdiction of the Sharia Court or outside of the jurisdiction or not. It is becoming a conflict as it dictates which legal system governs the resolution of specific issues. This conflict is evident in a notable case which is Nurullah Muhammad Habibullah versus Yusuf Maldona. In this case, the applicant and respondent were married at New Zealand and therefore registered their marriage in Australia. They divorced in Australia when the wife was pregnant and she later gave birth in Malaysia to their child. The wife, who is Malaysian, got a court order for custody for the child, and husband, who is foreigner, wanted to set aside the court order. He argued that since both of them are Muslim, the civil court had jurisdiction to hear the application for guardianship of the child. The court decided that the Selangor Islamic Family Law enactment did not apply because the marriage was not registered, so the High Court could indeed make that order as the Sharia Court is not applicable. Next, the conflict that arises is when someone converts out of Islam, which is apostate. Which court should the case be tried, whether in the civil court or in the Sharia court? This conflict has been illustrated in the case of Sun Singh versus Pearl Kim. The person involved was raised as Sikh but converted to Islam. Later in July, they renouncing Islam through a formal declaration. Since the person was under 18 at the time of the initial conversion, their lawyer argued that it was not valid. However, the lawyer representing the Islamic Religious Department of Kedah raised an issue about which court had the right to decide the matter, insisting that only Sharia court had jurisdiction, not the civil court. The court rejected the application, stating that according to fatwa, someone who renounced Islam through a formal declaration or undergoes a ceremony to embrace another faith remains legally within Islam until a Sharia court officially declares them as an apostate. From this case, it can be said that in deciding if someone's conversion to Islam is valid or not is seen as religious matter. This means it is a job of the Sharia court, a religious court, to handle and decide these issues. Furthermore, in the case of Muhammad Habibullah bin Mahmud versus Farida binti Datuk Talib, the court held that when there is a challenge to jurisdiction, the correct approach is to first see whether the Sharia court has jurisdiction and whether the state legislature has power to enact the law conferring jurisdiction on the Sharia court. Lastly, conflict between civil court and Sharia court happen when one person practices Islam and the another one is not. Schedule 9 List 2 Clause 1 of the Federal Constitution specifically confines the jurisdiction of the Sharia courts to individuals practicing Islam. Therefore, attempting to expand the authority of the Sharia court over non-Muslim contradicts the Constitution and is deemed unconstitutional since there is no basis for jurisdiction over non-Muslim. There is one case that highlighted the challenge where the jurisdiction of the Sharia court were extended over a Muslim, contrary to the constitutional boundaries outlined in Federal Constitution, which is in the case of Subashini, anak perempuan Raja Singgam versus Saravanan, anak lelaki Tagore, and other appeals. In this case, a couple married under civil law and had 2 children. Afterward, the husband converted to Islam and also converted their son without the wife's knowledge or consent. The wife sought an injunction from the High Court claiming the son's conversion was done without her permission. However, the High Court, the majority agreed that they did not have the authority to hear the case. The Federal Court in its ruling stated that the marriage does not automatically dissolve upon one party's conversion. In the Subashini case, it shows how differently non-Muslim and Muslim parties are treated when seeking to dissolve their marriage due to the spouse's conversion.
Next, the impact of the conflict between the civil court and the Sharia courts. Clause 1A of Article 121 was added to prevent the civil court from interfering with the Sharia courts. It states that the civil court cannot hear cases that fall under the Sharia court jurisdictions. As a result of the modifications, the civil court lost jurisdiction over matters over which the Sharia court has jurisdictions, as decided by the Supreme Court, and the Federal Court is in many cases. A person should consult the state legislation creating the Sharia courts and granting them authority in order to determine if the Sharia court has jurisdiction over a particular situation. Islamic law, Waqf, personal and family law of Muslim are a few examples of the subject covered by the state list. In the case of Dalit Kaur and Pegawai Polis Bukit Mentajam and others, the mother claimed that her son was a Sikh when he died. But the civil court decided that the Sharia court was competent to decide the case. Another case is Sunsit and Perkim. Civil court judge take the approach that Sharia court are competent and have jurisdiction in determining opportunist cases. However, problems in 2 areas remain unsolved. Firstly, even though the subject matter is within the jurisdiction of the Sharia court, one of the party is not a Muslim. Bear in mind that the Sharia court has jurisdiction over Muslim only and that Malaysia is a multi-religious country. Secondly, when in a case, even though all the parties are Muslim, some of the issues or matters are within the jurisdiction of the Sharia court and some are within the jurisdiction of the civil court.
There are several approaches to resolving jurisdictional conflicts between Sharia courts and civil courts to determine which court is more relevant and competent when issues related to Islamic law arise. One method of resolution is by employing the subject matter approach. This approach can be executed by referring to state enactments to ascertain whether Sharia courts are explicitly granted jurisdiction in that particular matter. The subject matter approach has become a benchmark for jurisdictional conflicts involving both Sharia and civil courts. One of the example of cases related to jurisdictional conflicts between civil and Sharia courts using the subject matter approach is the Wan Chan case against the Federal Territories Council. In this case, the widow obtained an interlocutory injunction to prevent the body from being handed over the council. However, the council challenged the jurisdiction of the High Court, stating that the case falls under the jurisdiction of the Sharia Court in Kuala Lumpur. Section 55, Clause 2 and Clause 3 of the Administration of Sharia Legal Profession Enactment 1952 of Selangor, applicable to the Federal Territories, does not provide jurisdiction to the Sharia Court to decide on a person's religion at the time of death. This argument was supported by referring to Article 74 of the Federal Constitution, the second listed list in the Federal Constitution, Amendment 121 Clause 1A of the Federal Constitution, and section defining the jurisdiction of the Sharia Court in the Islamic Law Administration Acts or enactments of the states. Justice Yusuf Chin stated that if state law does not explicitly grant jurisdiction to the Sharia Court for a matter listed under the state list, the Sharia Court is excluded from handling that matter. Jurisdiction cannot be implied. The remedy-prayed approach is also one of the methods used by Sharia and civil courts to resolve jurisdictional conflicts when issues related to Islamic law arise. The remedy-prayed approach means seeking an order or action. The Sharia court has jurisdiction to decide matters specified in the second schedule of the state list, even if the provision regarding the subject matter is not explicitly and clearly stated but can be understood implicitly. The jurisdiction of the Sharia court is clearly listed in the state list in the 9th schedule of the Federal Constitution. The existence of Article 121 Clause 1A of the Federal Constitution has clarified that the High Court cannot have jurisdiction over any matter already granted to the Sharia court. The Sharia court has exclusive jurisdiction even without specific provision in the enactment. Thus, by using this approach, the court will determine whether the remedy can be obtained in the civil or Sharia court. This approach was highlighted in Majlis Agama Islam Pulau Pinang and Isa Abdul Rahman and another. The Supreme Court decided that the High Court has jurisdiction over the case, although the issue was wakaf. The rationale was the Administration of Muslim Law Enactment 1959, Pening, did not provide for the remedy of injunction, and the Sharia Court did not have jurisdiction of issue an order of injunction prayed for in the suit. The remedy of injunction is provided by the Specific Relief Act 1950, and the rules are found in the Rules of the High Court 1980, in which power was given to the High Court to issue. Therefore, the High Court could only hear the claim for a perpetual injunction in that case, even though wakaf is within the jurisdiction of the Sharia Court.
Conclusion: the Islamic legal system was extensively integrated into Malaysia in the 15th century. The Malaysian court system, shaped by the 1807 Charter of Justice, blends historical influences with legal developments. The adoption of the British judicial system established the Federal Court as the highest court. Malaysia's 1963 formation introduced the Court of Appeal, Federal Court and 3 High Courts. The Sharia Court, initially embraced in the 15th century, underwent restructuring under British colonial influence. A pivotal 1948 amendment to the Federal Constitution granted exclusive jurisdiction to the Sharia Court, known as the Qadi Court, emphasizing its role in implementing Islamic law. And then in Article 121, it clarified civil and Sharia court jurisdiction, preventing civil court interference in Sharia matter. Challenges persist with non-Muslim parties and overlapping jurisdiction, requiring resolution for legal harmony in Malaysia's diverse context. The Ng Wan Chan case illustrates the subject matter approach, emphasizing jurisdictional grants, while Majlis Agama Islam Pulau Pinang and Isa Abdul Rahman reflects the remedy-prayed approach, allowing courts to determine jurisdiction based on sought remedies. These approaches signify ongoing efforts to navigate jurisdictional conflicts between Sharia and civil courts in resolving Islamic law matters.